Hey guys, back again, soceprep.com. We got Travis Britt. Let's look at this question right here. I provide this on my website, soceprep.com. If you buy one of my study guides, you get this practice test, which is a bank of thousands of questions. And I give you a clock, right? It's a real deal, right? It's just like you'll sit down and face it, Pearson view. But let's work through this question using our test taking strategies that I teach on my website as well. The question says, in the case of Tennessee v. Garner, right? So I told you anytime you see that V, right? We're talking about a lawsuit, right? And I see those letters following USC. So we're talking about United States Supreme Court. So in the case of Tennessee versus Garner, the United States Supreme Court ruled that. So I'm going to really need some background on Tennessee versus Garner. Thankfully I do. But if you wind up with one of these questions on the test and you have no clue whatsoever, use your test taking strategies, which is right. There is going to be one right answer. There's going to be 3 incorrect answers. So eliminate as many as possible and make the best guess that you can make, right? So let's work through this. Tennessee versus Garner was a case in Tennessee. Tennessee had a state statute that said that police officers could warn once and shoot, all right? So stop and shoot law in Tennessee, early days in Tennessee, they had a statute that basically said if somebody had committed a serious crime, that if they were told to stop by the police, stop or I'll shoot. And it was basically justified at that point. They could shoot and use deadly force in order to apprehend individuals that had committed crimes. So pretty aggressive police work, extremely aggressive, right? And we're going to find out that it was not even constitutional, right? So an individual 15 years old, a suspect that has just committed a burglary, police come in contact with the individual. He's a young, dumb kid. What does he do? He runs. He starts to climb a fence. Police officer says, stop or I'll shoot. 15-year-old kid did not stop. The cop did shoot. He did kill the 15-year-old. And his dad's going to sue on his behalf, basically say it was unreasonable search and seizure. They seized his life, right? So it's a violation of the Fourth Amendment. 1983 claim winds up all the way in the United States Supreme Court. And the justices are going to decide that if an individual uses force of not an individual, a law enforcement officer uses deadly force on a forcible felon, they must be able to articulate that the apprehension was absolutely necessary to prevent death or serious bodily harm to citizens, right? So they basically said that, hey, this Tennessee state statute is going to have more prongs than just stop or I'll shoot your ass, right? So they need to add in that if you do not apprehend an individual, that they pose an immediate risk to the public. Not just an immediate risk of basically like this is like school shooters or terrorists, right? Like if I don't shoot this dude, I can't hawk him down and arrest him. If I don't shoot him, they're going to kill more people. So an example where Tennessee Garner could be cited, and they said that was a good shoot. Like a school shooter leaves out of an elementary school after they just shot 9 children and they're starting to enter into a middle school, right? I'm taking that shot. They're not getting in that middle school and killing any more kids, right? Tennessee versus Garner is what I would put in my report. That I was not going to tolerate them hurting any more children, right? So with that being said, Tennessee versus Garner, they shot the 15-year-old on Tennessee state statute, stop or I'll shoot. The United States Supreme Court said, can't do that, guys, right? It is a violation of the Fourth Amendment to just shoot people because they won't listen to the police, all right, and go prone out and let themselves be arrested. If you're going to do that, you have to be able to articulate that they pose an immediate threat of death or serious bodily harm to the public, right? Like if you don't make that arrest, somebody else is going to die, essentially. So let's work through this, right? Gave you what Tennessee versus Garner was, United States Supreme Court case, one of the highest courts or the highest court in our land, the 9 justices that are the most prudent picked by the president. So A says that in matters of use of force in reference to the Fourth Amendment, that officers must be held to a standard of other reasonable officers acting without the benefit of hindsight in a similar situation. That sounds like objective reasonableness. Good night. So I'm going to hold on to it. I'm not absolutely certain, but I like the fact that it talks about Fourth Amendment, unreasonable search and seizure. But it sounds like objective reasonableness, right? Objective reasonableness. So I'm going to hold on to it as a contender. I'm not absolutely sure. B says that juveniles should be afforded the same due process rights as adults. We know that's true. N. Galt was the case, a juvenile, but I don't think it has anything to do with Tennessee versus Garner. But maybe they tricked me with this one because I do remember that Tennessee versus Garner had to do with a juvenile, but I don't think they shot the juvenile because he was a juvenile. They were just adhering to Tennessee state statute at the time, stop or I'll shoot, right? They would have shot him whether or not he was an adult or kid. He was a criminal that wasn't listening to the police per Tennessee state statute. It was a good shoot at the time. In Tennessee, federal courts are going to say otherwise. So maybe you keep it, maybe you don't. All right, let's move on. C says that citizens must not be compelled or coerced to self-incriminate. All right, I feel really good about this one because if we're talking about a United States Supreme Court case, I know that's Miranda. I know that's Miranda versus Arizona. And I know that that's going to be the Fifth Amendment. The Fifth Amendment protects you from self-incrimination. It's not a Fourth Amendment case, so I'm going to scratch that off the board. It's not good. And then D says that police officers may use deadly force as a means to apprehend a fleeing forcible felon if a reasonable and a prudent officer in a similar situation, again, the subjective reasonableness, would have articulated the felon pose an immediate threat to the public if he or she escaped apprehension, right? So if I don't arrest this person, they're going to hurt or kill somebody else, a citizen that's innocent, right? So that sounds a lot like Tennessee versus Garner, but I'm going to go back to my choices because I confused myself a little bit. A, I'm going to scratch it now because I don't like it as much as I do D. B, I'm going to scratch it now because I don't like it as much as I do D. And C, I've already scratched. So I've narrowed it down to my correct answer. D is the correct answer, guys. Tennessee versus Garner. That police officers may use deadly force as a means to apprehend fleeing forcible felonies if it's reasonable and prudent. The officer could articulate that if they were not apprehended, that citizens would die or face serious bodily injury as a result. So D was your correct answer. I'm going to pick it, stick it, and move on, right? Guys, if I can help you, SOCEprep.com. If you're in a basic recruit training program or you want to transfer your certification to Florida, you're going to have to take equivalency of training. You're going to have to pass the SOCE. So let me help you. SOCEprep.com. Travis Britt, hit me up in the comments if you got any questions, guys. I would love to help. I would love to help. I would love to help. Thank you, guys. Have a great day.